Good evening. Thank you very much for joining us here on Urban Debate on Mirror Now. I am Heena Gambhir. What's common between Bal Gangadhar Tilak, Mahatma Gandhi, Bhagat Singh, Jawaharlal Nehru during the British Raj, MP Navneet Rana recently, and scores of people in between? Well, they all have faced sedition charges. IPC or Indian Penal Code came into force in colonial India in 1860, but had no section concerning sedition. It was introduced in 1870 on the grounds that it was dropped from the original IPC draft by mistake. Now, under Section 124A of the IPC, the offence of sedition is committed when any person, by words or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law. Now, viewers, in the British Raj, the penal provision came in handy to muzzle nationalist voices and demands for freedom. But in the recent times, the use or misuse of sedition law has been screaming from the headlines. In fact, tomorrow also in papers, it will feature in two headlines. One, because Centre is yet to clarify its stand on its colonial era law and has been asking Supreme Court for Tariq par Tariq. And second, because MP Navneet Rana and her husband MLA Ravi Rana were released from jail today, a day after they were granted bail in an alleged case of sedition. But tonight, viewers, we are talking about it because the top court, in a way, has given an ultimatum to the Centre to file an affidavit explaining its stand on the sedition law. The top court is hearing a batch of petitions challenging the constitutional validity of Section 124A of the Indian Penal Code that deals with the offence of sedition or deshtro. Now, these visuals that we are now going to bring to you, that you're going to see on your screens, are of contemporary instances of use of sedition law by various state governments. Jignesh Mevani, the Rana couple in Maharashtra, the accused in Elgar Parishad case, farmers' protest, the case of a Manipur journalist, a school in Bidar booked for sedition for hosting a play on CAA, the Pinjra Tod activist role in Delhi riots case. These are a few to be named. But before we dive into whether the law should remain or not, let us understand what the law really says. So as I mentioned earlier, as per Section 124A, whoever by the words, either spoken or written or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years. Now, viewers, what's also important to note is the data released by the National Crime Records Bureau for cases of sedition. Now, this data reflects the disutility of the law for the criminal justice system. For example, in 2020, 73 cases were registered under sedition, but the conviction rate was 0. Yes, in 2019, 93 cases were registered with 2 convictions. And in 2018, 70 cases were registered with 0 convictions again. So data corroborates the existence of weak legal grounds to invoke the law in most of these cases. So tonight on Urban Debate, we want to ask the legal experts and seek their opinion on one question. Is a sedition law worthy of existing in Indian law books? And joining us on the broadcast this evening are my guests, and we'll of course be asking that pertinent question. We have Karuna Nandi, Senior Advocate Supreme Court, live with us, Geeta Luthra, Senior Advocate Supreme Court, Satyapal Jain, former ASG, Kailash Vasudev, Senior Advocate Supreme Court. Appreciate all of you. Thank you very much for joining us here on Urban Debate on Mirror Now this evening. Mr. Satyapal Jain, I want to begin the discussion with you. First, I want to understand from you, it's easier to invoke for the center, it seems, but difficult to explain. Why is the center taking so much of time to clarify its stand on this colonial era sedition law?
I'm not aware of the facts of the matter pending in the Supreme Court, but in the normal routine, whenever such matter comes, and you have to file an affidavit in the Supreme Court in any such policy matter, especially when the Supreme Court is hearing a petition about whether to refer it to even a larger bench. Kedarnath Singh case was 5 judges bench. So in that case, it does take time, and in the courts ordinarily in almost all the matters, governments do take time, even the private clients do take time. But I think the position of the government of India, by and large, to some extent, has been made clear by Mr. K.K. Venugopal, the Attorney General of India, who said that even he is in favor of retaining this law in the law book. And so far as the government of India is concerned, by within 3-4 days or within a week, the reply will be filed, because the Supreme Court has listed the hearing on 10th of May, afternoon at 2 p.m. And I'll tell you, see, in the Supreme Court or in the High Courts, whenever such matters come and where there is a national debate going on, in the courts also, TV channels also, in public also, the government ultimately takes a decision in consultation with all concerned, including the Law Ministry, the Parliamentary Affairs Ministry. I don't think there is anything very serious that the government doesn't want to file the reply, or government is not able to take its stand clear. Within few days, the reply will come. That is my belief.
Okay. Ms. Geeta Luthra, the case started last year in July, and enough time, don't you think, has been given to the center? But what we are now seeing is another response from the center on the eve of this hearing, wherein center sought more time. Why, in your opinion, center is seeking more and more time, anti-national or not? That's, I think, one decision on which center has to clarify.
So, why do you think the center is taking more time? The Law Commission has recommended abolition of the sedition laws. Britain, from where the law was founded and from where it came into India, has abolished the law. Sedition was introduced into India basically because it wanted to take and quell anti-government protests against the British government. Now, in a time and era as India 2022, when we are so much invoking freedom of speech, and when sedition law is being misused for the last several years, I mean, I'm not talking of one government or the other. I'm talking of somebody somewhere thinks, why don't I invoke sedition when I find nothing else? When there is a speech which is unpalatable, somebody says, do something about it. They say, okay, let's invoke sedition. By the time it's proved, the matter will die down. Now, the government also knows that they may want to keep it on the statute book, basically to prevent anti-country or anti-nationalist propaganda. But that can't be a reason to not revoke it, because the purpose of the law and what Kedarnath's Supreme Court judgment really says is it should not be regarding the party in power, but the state, that 124A can be revoked, can be invoked. But it is being invoked even at the drop of a hat. Now, it's a very powerful tool in the hands of government. And therefore, I think what Mr. Venugopal says, that perhaps Kedarnath should be referred to a larger bench, perhaps, and it is a good law, but I don't want it to be revoked. At the same time, he says maybe my stance may be slightly different, if I'm not mistaken. This is what he said today. So taken in an overview, it is a law crying to be revoked, but every government seems to feel that it needs it to suppress people who are not speaking with their voice. And that's why it's a very, very powerful tool. And you may get a quashing, you may get bail, but by the time you get a quashing, by the time you get bail, you know that the entire purpose has been served of invoking sedition law. Perhaps that's the reason why government is having so much to think before it is saying what its stance should be.
Interesting. It's a powerful tool, you say, and also we know at the heart of the sedition law, Karuna Nandi, is the term disaffection towards the government, and the way it is being used today. In a democracy, we all know disaffection should be allowed to be expressed in voice or in written letter instead of actually being allowed to be expressed in form of a vote against the government.
So if we looked at the plain meaning of the words, of course, you'd be right, because the word disaffection against the government, surely that's the role of any opposition in a democracy, right? However, that aspect has, in fact, to be fair to a very, very bad law, been read down in Kedarnath, right? Now, the problem with Kedarnath, I think, is slightly different. The problem is that it stated the law incorrectly at the time that it was decided. Because it said a number of things. It spoke of incitement to violence, etc. But it also, unfortunately, spoke of the tendency to incite violence. What's wrong with this bad tendency test? This bad tendency test means that it's overbroad. Now, if it's overbroad, it means that it gets rid of speech that is permissible as well as speech that is not permissible. Surely the person who is inciting the violence or doing the bad act should be penalized. Or if there is a proximate connection between the speech and the violence. Now, why is this judgment bad, and why is this 3-judge bench equipped to get rid of the 5-judge bench in Kedarnath, which has been doing so much damage to our democracy? Which is the judgment, as the Chief Justice noted correctly, that affirms, that fails to get rid of the law that imprisoned Mahatma Gandhi. The reason is this, that 2 years prior in Ram Manohar Lohia, a 5-judge bench had said that there must be a proximate connection between the speech and the violence. So to water it down and to say that that a tendency to incite violence is enough to imprison someone is just plain incorrect. On legal words in Latin, which is sometimes used in court, per incuriam. Subsequent judgments like Jagjeevan Ram say that the words must be a spark in a powder keg that incite the violence, right? In Shreya Singhal, Justice Nariman said quite clearly, I was one of the counsel that had appeared in the case, he said quite clearly that even advocacy of violence is not sufficient to reach a criminal standard, that incitement is what is required. So therefore, Heena, I think that there's a very clear, democratic, technical reason that this 3-judge bench can decide and get rid of this judgment that is doing so much damage to our democracy. So to the extent to which I agree with what the Attorney General said in court today is that in addition to the law being bad, the law is also being misused. Now, to the extent the law is being misused, there was an order in the early days of the hearings of Shreya Singhal, an interim order, that said that a IG of police or similar, that you shouldn't be able to file a complaint, or no action should be taken, and register a complaint rather, without an IG of police or someone similar really sort of making sure that you're taking a look at it. But I think the larger problem is the law at the time it was decided, it was bad, and you don't even need a 7-judge bench. A 3-judge bench, in my view, is sufficient to decide it, because that judicial discipline in something that goes to the heart of democracy is vital. And subsequent judgments, in fact, explicitly follow Ram Manohar Lohia, and that is the line that must be upheld.
Right. Interesting. Mr. Kailash Vastev, now, the Law Commission of India, in its recent consultation paper on sedition, which was published in August 2018, if I'm correct, observed that while retaining the offence of sedition was essential to protect national integrity, it should not be used as a tool to curb free speech. So the government has a recent reference too. Then what explains this delay?
These are massive delays, filing of affidavits, procedural. They are all a part of the system. We have got used to it in the judiciary. We cannot compel anyone to file an affidavit in a specified time. If they want time on issues like this, the courts normally grant it. I don't make much capital on this delay. What we must make capital of is sedition law per se by itself. It starts with the penal code, goes back to the 1880s. And has come into force and has been used time and again, basically for the purpose. See the chapter in which it is located. The first part of the section deals with waging war against the country. Then you come to sedition. You come to the later part where it is said that waging war against those countries which support our government. Now, these are basically colonial laws which are brought in by the British for the purposes of retaining control on the colonies which they had under their flag. We don't have any countries under our flag. We are a non-aligned country, which is secular democracy, which works for the betterment of people. So therefore, to my mind, many of the sections in the Indian Penal Code, which were drafted and incorporated in the 1800s, don't deserve to go. For example, I'll read out one to you. Committing depredation on territories of power at peace with the government of India. Waging war against any Asiatic power in alliance with the government of India. So you see, these are laws which came into force for a different purpose, basically to retain control and to ensure that you were in a position to put down any revolution which might take place against the government. Today, what we are doing is political dissent is being treated to be sedition. See the cases of Vinod Dua, see the cases of Patricia Mukherjee. All these are journalists of great eminence. You slam 124A against them, keep them in custody, get them filed in different areas which they can't defend. Vinod Dua's case was filed in Himachal. He's never been there. He's a resident of Delhi. Just because he covered an article, somebody files a case in Himachal, this man has had to suffer the whole consequence of a couple of months of hearing. Patricia Mukherjee doesn't belong to the Senate. She belongs to a state in the northeast, so you file another state. The lady is defending herself to the Supreme Court, comes and says, this is bad, you can't maintain these proceedings. We must look at the law of sedition in the context of law as framed in the Indian Penal Code in the 1800s. We are now 200 years ahead of such the laws were framed. They are no longer necessary in our system because we've got a constitution of 1950, which sets out our rights, including those in Part 3, that is Article, the whole fundamental right chapter. So if you have fundamental rights, you also have a right to criticize. The right to criticize is an essential right in a democracy because there you can say what you want with regard to what you feel is incorrect about governments. No government is permanent. It comes for 5 years. If re-elected, comes for another 5. Not re-elected, somebody else comes. When somebody else comes, sedition comes in because by saying that, look, this is what you said at that point of time. So therefore, I now charge you to keep you quiet and not criticize my government. No government is permanent. No system is permanent. No citizen is permanent. Times go by, but history then tests all those who have come into the picture and abuse the system for the purposes of securing the private interest in governance. This act of sedition, this law of sedition has to go. Sustaining it is contrary to democratic principles because you have got other powers. You've got so many acts. You have the Terrorist Act, you have the money laundering, you have 10,000 acts under which you can put a person into custody. Why use an act which is archaic? And what is interesting is more than 10,000 cases have been filed in the past 15 years. Conviction is not there. But those poor persons against whom we filed the suits or petitions, the pleadings, have been facing the consequences over the years. Therefore, either you strike it down or don't use it. Guidelines laid down in the court, starting from the Bihar case in 50s, have not taken the law any place. The court must strike it down, put an end to the sordid chapter in our democracy, and let people live a free life in accordance with the mandate of the Constitution.
Interesting points you've raised. Mr. Satyapal Jain, if the government thinks that it is needed, then why can't the government say it without delay? And otherwise, if it is redundant, why can't it simply say no? Because if we look at the data here, sedition cases, as I was mentioning earlier too, reported in the year 2020, 73. No conviction, 0 convictions. In 2019, 2 were convicted and 93 cases under sedition were registered. So what is the government really waiting for? Because, in April, the government had said that since 2014, 1,486 obsolete and redundant laws have been repealed. So why such cloud over sedition law in India when there is an acknowledgement that it is being misused?
In favor of repealing the sedition law, section 124A, which deals with that, are 2 arguments. Number 1, that it has been misused by the different state governments in a number of cases. Number
Even
2,
central government.
Eh?
The central government, whether in Congress,
also state also. Number of cases, the Maharashtra was the state government. Maharashtra is not the central government. So therefore, it has been, this is the argument being given that since it has been misused by the government, therefore it should be repealed. Second is that the conviction rate is less. It's not as expected or ordinarily it should be. I will with all respect submit that in case we accept these 2 arguments for repealing any law, my learned colleagues will agree, not only this section, not only this law, there will be many laws which may have to be repealed. Simply because some act is being misused, it doesn't mean you have to repeal it. May I ask a question? Which law in this country, which section by and large of the IPC has not been misused? You see the number Dowry cases, you see the murder cases. If you go to the analysis of the data in different cases, you will find how many people are falsely implicated, involved, and ultimately they are acquitted. My submission is 2. Number 1, that this law, I'm in favor of retaining it on the law book. But I agree with Mr. K.K. Venugopal that you have to lay down certain guidelines. The guidelines have been laid down by the different courts. My friends, colleagues were citing different judgments from 52 onward, this case, that case, and ultimately Kedarnath Singh's case, which is now being considered for referring to a larger bench. See, the biggest guarantee of any misuse of any law in India are the courts. We have seen in number of cases, whether it is Maharashtra or Himachal or any other case, that the courts have been frowning upon such cases where there is a misuse, giving them the relief, whatever is there. So therefore, the biggest guarantee, number 1, are the courts. Number 2, the judgments. If you go in detail to the Kedarnath Singh's case, the Kedarnath Singh's case has explained everything in detail. You cannot say that any person may say something, incite violence, and still, no, we don't call it. I think to that extent, I will not like to go. My submissions are 3. Number 1, so far as the central government is concerned, as Mr. Vasudev rightly pointed out, in court, sometimes there is a delay in filing replies. It's not only with one government or the government party, not with the private parties. The court has given them time. I am very confident by 10th, the case will come. Number 2, if there are any guidelines more to be laid down, it should be laid down.
I don't think, Mr. Jain, the argument that state governments have misused is not tenable, because Delhi police recently imposed sedition law. Now we all know who runs Delhi police. Then who rules Karnataka, where students were interrogated in sedition cases. Karuna Nandi also wanted to come in. Yes.
Maharashtra, Ravneet Rana.
So any state.
I think
I
the
want
Yes,
to come
so
in
it's
here.
being
to be
used,
made
misused
here,
by
Mr.
everyone
Jain,
now.
is that, and I think the central point to remember is that the misuse is not the central objection to the law. That's a side objection. The law is bad. The reason the law is bad is because despite the reading down by the Supreme Court, the reading down was bad. The reading down was bad because if you have, take Mr. Jain and take actually, Heena and all your viewers, an example where a man is standing in front of 100 people wielding swords, or all fired up with mashals, right? And he says, go and burn some houses, right? Now that's very clear. That's incitement to violence. If it's a little more subtle, and if he says, this settlement deserves to be destroyed, right? So the thing is that speech is something that goes in a spectrum. If there is a man who is saying that, let us get onto the streets because I love this country and we must protest in a loving and peaceful manner, right? Then I think we have a bit of a problem, because if one person then goes and does something, or even if they don't do something, remember that, even if out of that crowd, nobody does anything, a FIR may be registered and even a charge brought, saying that, look, this coming down to the streets, this has a tendency, because the word tendency is a very loose word. And the word tendency opens the doors for all kinds of democratic speech, for all kinds of protests that have been upheld as being a valuable part of our nation and being a valuable part of government being able to hear what's going wrong so that they can fix it. If government doesn't know what's going wrong, how is it going to be fixed? That is what distinguishes us from a colonial power. And that, sir, is why the law is bad. And that is why the misuse is not the central problem. The misuse is a reality, like in Siddiq Kappan's case. But what is really central is the fact that Kedarnath got it wrong, and they failed, unfortunately, to follow Ram Manohar Lohia, which was binding precedent on them. And this is something that a three-judge bench is perfectly.
No, but in Madam Karuna Nandi, what you are saying has
Interesting.
already been
Satyapal Jain sir also wants to respond. Misuse is a reality. One second, sir. So misuse is a reality is what Karuna Nandi has said. So let's move forward in the
she's
debate
not
and
saying
try and
that. She's
understand
saying-
what should now be the way forward. No. 1 second. Like the AG also reiterated, his stand that misuse has been controlled, but of course it's happening. So should there be now clear guidelines that this is the, point where it can be used, this is the point where it can't be used, or it should be repealed? That's what I now want to ask each one of you. Let's begin with Satyapal Jain, then Geeta Luthra.
In Balwant Singh's case, what he had said was, ਖਾਲਿਸਤਾਨ ਜਿੰਦਾਬਾਦ ਰਾਜ ਕਰੇਗਾ ਖਾਲਸਾ and ਹਿੰਦੂਆਂ ਨੂੰ ਪੰਜਾਬ ਚੋਂ ਕੱਢ ਦਾਂਗੇ, we will throw out the Hindus from Punjab. ਹੁਣ now the time has come for taking and all that. See, the Supreme Court did not accept it as a case under the Sedition Law. The Supreme Court in Balwant Singh's case said that unless there is a violence which follows, or unless the violence is incited. So what I'm saying is this, that the courts have always interpreted the law in the right perspective. They have not, there is no case of, at least not to my knowledge, where this section has been misused and have been upheld by the court.
Okay.
The courts are the best guarantee against the misuse of
Okay,
the law.
Karunanandi
The law must
disagrees.
stand.
I'll give her
I'm in
time to
favor of
respond, but
the-
before that,
Yeah.
Geeta Luthra wants to
Yes.
come in.
Yes. So courts
I'll let
maybe
Ms. Luthra go first.
1 minute. Nobody and everybody does not have the ability to approach the Supreme Court of India. When Dr. Binayak Sen's case came to the
Yes.
Supreme Court of India, it took more than, I think, a year or couple of years. He ultimately was able to get bail from a bench of Justice Kaju and I think Justice Deepak Verma. That's not the argument. It cannot be that the courts are a citadel, so let there be abuse and let the abuse then be 1 minute, I'm completing. Let the abuse be redressed after 5 or 10 or 20 years by the Supreme Court. Just look at the section. Forget the abuse for a moment. Forget the misuse for a moment. Is the law the way it stands? Is the law which speaks of the government as opposed to the state, is such a law something which should be allowed to continue in a free India where the Constitution ensures you freedom of speech? You have to test it with Article 21. You have to test it with your fundamental rights. And you will say yourself that Kedarnath may have watered down the law. But the fact is, if it has been repealed in the very country where it came from, and where the purpose was said that some of these people are illiterate, and therefore to control them, we are bringing this law. I'm not using the exact expression because it's too harsh and it's too based against one party or one community or one person or the other, and therefore is not in very good taste. But should such a law, with the language used in such a law, be allowed? Is guidelines are guidelines enough? And according to me, guidelines are not enough. This law should not continue. There is 153A. There are other enactments. I don't agree with Mr. Vasudev that PMLA, etc. are, something, they are also open to abuse. Misuse of a law may be redressed by guidelines, but if a law on the face of it is bad, because the language used was something which was a colonial language, then such a law should go. And that's what Law Commission has said.
Such a law should go. Okay, Mr. Kailash Vasudev, though the British brought sedition law to India, the UK, incidentally, we know, repealed the law in Britain only in 2009 with effect from early 2010.
Correct. You see what I was saying, Geeta, I just want to clarify. I'm saying there are other laws under which you can take these measures. You don't need the Sedition Act.
Yeah.
That's what I'm saying. I'm putting it in that light. Now, coming back to the main question. You see, abuse of a law is a right of government. Because it is there that they exercise absolute powers. To lay down guidelines for an act which per se, or for a provision which per se is not in sync with the Constitution, is a different situation. You cannot have guidelines to rectify and incorrect actions. Two wrongs don't make a right. We have a sedition law, which the Law Commission says has been abused, which judgments of the Supreme Court say have been abused. Justice Madan Lokur's quotations are classic. Justice Deepak Mishra, when he was granting bail, are absolutely remarkable. So you look at the law as it has developed from 1950 to date. Not a single judgment of the Supreme Court supports the sedition law. It may, in a particular fact circumstance, take a particular situation. Because the law has not been struck down, the court is obliged to decide. The court should now strike it down so that this particular parameter of our existence comes to a halt. Abuse, misuse, arbitrary actions, these are matters of judicial interpretation. But to have that, you must have a statute. If the very substratum is not there, you won't have an abuse, you won't have a misuse, you won't have arbitrary action. Therefore, strike down this
Okay.
law, proceed further. You have other provisions under which you can take action for anti-national activities. I mean, Geeta, to supplement you, the Army Act, Navy Act, CRPF Act, all these acts are provisions. Insofar as the working of the system is concerned, your intelligence agencies have their own systems. You have 10,000 laws, as I said, for purposes of taking action against those who work against the nation. State governments, central governments are now using this act for the purposes of their own benefits and for the purposes of showing that they are in power. So don't say anything against us. Even if politically we are wrong and we will maintain it. That is not the purpose of the sedition law. Sedition law says against the nation. It does not say against a political wish. It doesn't say against a political party. It does not prevent you from criticizing an action which you might feel is wrong. If you take it that way, democracy will be fractured. You will not have any progress. You will not have an open discussion on an issue which might affect more citizens than you think it does.
Okay. Ms. Karuna, is there need to now look beyond the fact that law has been misused, maybe see if it's bad in DNA and origin?
You know, the law as it stands now is bad. I don't think there's any doubt about that. When 3 Kashmiri students are charged with sedition for allegedly posting celebratory messages on social media for Pakistan's victory over India in a T20 match. This was October last year, so 2021, right? There's another case of a young filmmaker called Aisha Sultana from the Lakshadweep, who's facing sedition charges for saying that the Union Territory's administrator, Mr. Praful Patel, was quote-unquote a bioweapon. Now, these are intemperate things to say. Does it mean that there should be a sedition charge, or is it a misuse of the law? Arguably, it's not a misuse of the law. You know why? Because what the law says is that if there is a tendency to incite violence. Now, that word tendency is extremely vague, it's extremely broad, and that broadness and vagueness is something that anyone who wishes to use it can use it against anyone whose speech that they don't like. And our state governments and our central governments have a notorious tendency to use whatever laws exist against speech that they don't like. And honestly, it's across the board. However, under the BJP government, it's absolutely clear, if you look at the data, that the number of sedition cases in BJP-ruled states are significantly higher. It's also true that Section 66A is something that the Congress came up with. And the Congress had the opportunity to repeal the sedition law, and they failed to do so. So where are we now? We are in a position where our Supreme Court, that came to the aid of young women who were being charged with Section 66A on the ground that that law was vague, it was overbroad, and that it had a chilling effect on their constitutional right to democratic speech. The Supreme Court now has a very, very important opportunity. And that opportunity is to get rid of the law that imprisoned Gandhi and today chills the speech, the democratic speech and the democratic values of the country that he fought for.
So clearly the ambiguity, the grey silent areas of the law that are there are the ones which are making it a handy tool for misuse. Mr. Satyapal Jain, you referred to the Balwant Singh case earlier. It was the Balwant Singh versus State of Punjab 1995. The Supreme Court had then dropped sedition charges against the 2 men who raised slogans in favor of an independent Sikh majority state outside a cinema hall in the aftermath of the assassination of former Prime Minister. I want to ask you, is the NDA government finding it a little difficult to take a stand against this sedition law, given the muscular nationalist political position that BJP, in fact, has taken in the recent years?
See, I like to clarify one thing. So far as the laws are concerned, these laws doesn't belong to any particular political party. That will be the stand of the Government of India. Fortunately, at the present, it is the BJP party which is in power. That will be the stand of the government of India as it exists today. Number two, my very senior learned colleague.
With due respect, may I just put out some data for you and for our viewers. The BJP was in power in 4 of the 5 states with the highest number of sedition cases during 2010 to 2020. Bihar, UP, Karnataka, Jharkhand. In UP, 77% of the 115 cases of sedition were registered since 2010. Is this the data that I have in front of me that I'm quoting? That's why I asked you that question. Why is there this perception there?
The other side argument could be that perhaps the earlier governments were soft on the cases which fell under the sedition law. They were ignoring those things. The BJP government, being a purely nationalist government, will not compromise on the national interest, unity and integrity of India, will not spare any person. So far as Madam Nandi gave certain examples, you see, you can give number of examples against misuse, abuse of different laws. We have seen as a lawyers, somebody convicted of murder ultimately after 20 years having been acquitted by the Supreme Court. Somebody falsely implicated in the rape case. Somebody falsely implicated for using some castiest remarks against any person, domestic violence and all that. What I'm saying is this, simply because you have 3, 4, 5 examples that according to you it's a case of misuse doesn't mean that the law has to be repealed. The question is, the true interpretation of the law has already been given by the courts. Balwant Singh's case, Kedarnath Singh's case, even now, Supreme Court is examining it, whether to refer it to a larger bench or not. That will be done on 10th of May. So let us wait for the verdict of the Supreme Court. We are nobody to pronounce on the validity or invalidity of the law. The courts have given number of judgments on that, and everybody is agreeing on that. Let there be clear guidelines. Everybody is against abuse or misuse of any law, not only the sedition law, but all laws of the land. Everybody should be against the exploitation or use or misuse. But to say that there are certain examples of misuse only of sedition law and there is no other example of misuse or abuse of any other law, therefore this law should be repealed, I am not agreeing with that. I am saying abuse or misuse is bad, maybe by any government, by any party. Number two, let the Supreme Court further lay down certain guidelines so that any chance of abuse can be minimized. If you can't, totally rule it out. And for that, let us wait for the Supreme Court on 10th of May. Their Lordship will decide 3 judges bench whether to go ahead with the hearing or refer this matter to a still larger bench, which will mean a bench of 7 judges because earlier judgment is of 5 judges.
Right. Interesting. Of course, we'll look forward to the crucial hearing. Okay. I want to give the last word now. I have very little time left. Geeta Luthra wanted to come in. 10 seconds to you, 10 seconds to then Kailash Vasudev, because he also wanted to make a point. Very quickly, both of you.
One aspect of what Karuna said, perhaps I don't agree. The way the judgment, Kedarnath and Vinayak Sen and all the judgments read, Kedarnath being a larger bench judgment, they do not read with the interpretation which Karuna is placing on it. So this one, although I still insist that it should or would wish, my wish list would be, it would be struck down. The interpretation is not as loose as Ms. Nandi is saying. I believe the interpretation as laid down in Kedarnath, in fact, distinguishes government, power and political power in party in power, does not talk only of tendency, does not talk in this. So it links it, and therefore the interpretation has been tightened. I still feel it should go, though. That's my 10 seconds or more.
Okay.
No, I'm afraid I have to respond to that.
Mr. Kailash Vasudev,
because
last
that's
10 seconds.
just, no, I'm afraid, Heena, I'm going to have to respond to that.
I'll give you also 10 seconds. I promise. Okay.
May I come in? Or...
Mr. Kailash Vasudev, closing comments.
My answer to your Judge Sahab is very simple. Any law which has guidelines does not work. Guidelines will have to be subservient to the main act. That's settled law. Guidelines being subordinate will not be able to supplant the law. The argument which everybody has been raising, not from today but for many years, is sedition is a provision which is abused. Should you permit it to be in the statute books after independence? Because in a free democracy, The right to dissent is a mandate. The right to prevent the dissent is an abuse. You use an abusive power when you have an abusive provision. If you don't have an abusive provision, you will have a democracy which will flourish. Take, for example, countries like Norway. The dissent is an accepted right. Countries in Germany, dissent is a mandate. Why can't we have dissent in a healthy system for the purposes of bettering our country? I am not able to understand that. Any political party comes, it says, no, I'm right, you're wrong. For 5 years, I will be right. After that, I might be wrong. What happens then? You've damaged somebody. You've harmed somebody. You've taken away a particular beautiful part of our democratic system. Is that your right?
Absolutely. Ms. Karunanandi, last 10 seconds, closing comments.
Well, Ms. Luthra, I'm now reading from the judgment, but it's more for the benefit of all of the viewers. And what the judgment says is this: keeping in mind the reasons for the introduction of Section 124A and the history of sedition, the section must be so construed as to limit its application to acts involving intention or tendency to create disorder or disturbance of law and order or incitement to violence. This is against our obligations under the ICCPR. It goes against legality. It goes against the requirement of certainty in law. And in fact, what Mr. Jain was saying, that it's not a political issue, it's not a governmental issue. Sir, it is very much a political and a governmental issue, not only because of what the anchor said about the BJP bringing all these cases, but more significantly, because you could at any time with this significant majority table a legislation to get rid of it. But failing that, our democracy, I think, is in the hands of our honorable judges, and let us see what happens. It is their prerogative.
Well, absolutely. We all will be looking forward to what happens on 10th of May with wise legal minds speaking. I felt I was in a courtroom today. Thank you very much, all of you, for joining us here on Urban Debate on Mirror Now this evening. I would add here, laws should be created and curated with care. A noted parliamentarian had once said, "Kaanoon aaj bante hain, pushte unke karan bhugatti hain." All eyes, of course, are going to be on the affidavit, the response of the centre, which centre has now been asked to file by 9th of May. Hearing in this case will happen on 10th of May. And Mirror Now will keep you ahead on this big story. Heading into a short break. Stay with us.